All right. Hi, Luke Carlson from LS Carlson Law. Today we will be talking about the changes in Florida law. We are honored with our managing partner, Jeff Kominsky, who oversees our Florida operation. Jeff, thank you so much for being on the show.
Absolutely glad to be here, and I'm really looking to shed some light on some of the recent laws in Florida.
Awesome. And I also have my producer, Marty. Marty, welcome back.
Hello there.
I'm a California lawyer. As I said, Jeff is a Florida lawyer, and Marty is the non-lawyer in the room. And we often think that that is very valuable because sometimes when two lawyers talk, we get to some weird, esoteric space, and Marty brings us back down to earth.
Yeah, it's a whole different language. No one knows what you're talking about.
It can be. So, yeah, let's just jump right into it. Again, Jeff, you're the thought leader here. You have the lead oar. So why don't you take it away?
So I think ultimately in Florida, as it applies to association law, the Florida legislature in the last few years has taken pretty significant steps in changing kind of the narrative, if you will, when it applies to homeowners versus associations. I think a lot of it really stemmed with what happened, unfortunately, in 2020 in South Florida with the tragic events of Surfside, with the Champlain Towers and the collapsing and killing of numerous people and community members. And the state of Florida really, and the whole nation took it very seriously. And what the state of Florida started to do is realize that associations and boards were really monopolizing the game. And so what they've started to do in the last few years is slowly trend towards balancing the ability for property owners and condo owners to have a stronger say and have more important rights to utilize and push back if necessary. So I think what you're seeing in as recent as last year and even this year, there's various laws that have been enacted and even new proposed laws that I believe are shifting this balance of power and rights back to property owners.
Yeah, it was interesting when I was preparing for this, going over proposed and enacted legislation. I mean, this is really empowering the homeowner, a lot of these laws, and it's really putting a lot of pressure, rightfully so, on really just bad HOAs. You're trying to correct a very systemic problem in Florida. And at least my interpretation was this really was geared towards empowerment.
You couldn't have said it better. I think from my perspective, in terms of what these laws have done, is they've taken small but significant steps in reversing the course that's been kind of stuck in neutral for the last few decades, where most associations have these boards that have used their power at will, and whether they're breaching their fiduciary duties or not complying with the various documents within your community, usually called governing documents. I think that now the Florida legislature has recognized that there's a lot of people moving down to Florida, especially since COVID, and a lot of people are recognizing that they need to protect themselves, their properties, even when they buy and sell. And so there's a lot of interesting things, especially when you're noticing some of the recent developments that have happened within the abuse of power of board members themselves. There was a really big case in Miami-Dade County called the Hammocks Association. It's one of the largest associations in all of Florida. And basically what they were alleging in the lawsuit was that board members were embezzling funds. And to the extent that people were imposed these massive special assessments that they just couldn't pay. And so based on those things, the various legislatures, and rightly so, have really tried to penalize and disincentivize any type of board member who might be thinking that they could try to take advantage of the position of power that they're in.
Yeah, well said. Well, let's jump into it. We have several laws that we'd like to discuss. Jeff, I'll let you.
You want to introduce it, Luke?
No, I think we let the resident expert discuss it. And Jeff, I think we should go down this list in terms of, first and foremost, what do you think is the most impactful? What is the most meaningful? And we'll work down the list at that point.
Yeah, so I think in terms of 2023, one of the most impactful laws that eventually was put into effect was House Bill 919, where it changed the Homeowners Association, but ultimately renamed it to add some more teeth to what board members were supposed to do and what they weren't supposed to do. So, for example, board members are now, even though they're volunteer positions, they're unpaid, they still have a fiduciary duty. They still have to act in the best interest of the entire membership, and they have to equally and fairly enforce the governing documents. And so what this House bill did last year was it allowed more legal teeth and adding ramifications to if board members weren't following their responsibilities and weren't following their fiduciary duties, and what that would do and what consequences that could have. For example, if a board member was indicted for some sort of crime, that indictment would then statutorily force out that board member to immediately resign. And it's hard to believe that it took until 2023 to get to that point. If a board member commits a crime, they're still allowed to be on the board. Sounds pretty bizarre. And so, with Florida being a high crime area, high white collar crime area, the state legislature, I think, took once again a small but significant step into trying to make sure that board members do what they're supposed to be doing.
Yeah, no, I really like this one because in my mind, it was very much geared towards deterrence, right? There's massive consequences if you act wrongfully, and it's really the state of Florida coming in and saying, yeah, these are the actual consequences. Now, this is what happens when you act wrongfully. And, in my mind, when a board understands that, hopefully it deters this conduct in the first place, as opposed to putting a whole bunch of more regulation around these boards. Now they actually have real consequences for their misconduct.
What I like about it the most is that it seems like the majority of this is just based on common sense. For instance, the prohibition on kickbacks. I mean, that is the most common sense thing. And then the conflict of interest disclosures. I mean, imagine that you can get kickbacks, and you have a fence company, and you are saying, "Oh, we're gonna initiate with the fence company," and you're getting kickbacks the entire time. To be able to limit that, or at least put disclosures on it, I mean, I think it's significant and just common sense. What I like about it is it's just based in common sense.
Yeah, agreed.
And one thing to add to in terms of conflict of interest, there was a world that we lived in Florida where if you lived in a condominium association, that if there was a board conflict of interest, that there could be consequences and penalties. But if you lived in a single family home in an HOA, there is no similar conflict of interest language. So whether it doesn't make sense at all, but one would have it and one wouldn't, just was really bizarre. And so I think that, the legislature was trying to cover up some gaps there.
Yeah, well, I applaud him for that.
And as we'll discuss maybe in a few minutes, there was a problem with this law in the sense that, yes, it added some legal teeth and consequences. But what ultimately happened in 2023 as this became law is the Florida state legislature realized that there was no enforcement arm of this statute. Who could enforce a statute like this? Could it be the courts? Could it be a court of arbitration? How do you enforce this? And so in 2024, as we'll discuss, the Florida's legislature realized that they needed to beef it up even a little bit more.
Oh, that's wonderful. All right, so that's 919. And all right, Jeff, what's next on your list?
Well, to me, I think there's one that's really interesting, and it is relating to the installation of properties. It is specifically House Bill 437, and that House Bill 437 statute, and that statute is now Florida's statute 720.3045. So this bill became a statute, and a brand new statute. And what this statute basically says is really fascinating to me, is it basically says that if you live in a single family home and you want to store something in your backyard, before this law came to be, an association would be able to penalize you for putting things in your backyard that might not have been approved. So for example, if you had a small pontoon boat, and you couldn't hide it anywhere, and if you did hide it or tried to, and the association still knew about it, they could come after you. Okay, what this law does is that basically says, look, if an HOA can't see it from the front of your property and they can't see something from the side of your property, and you have a fence up, you basically put whatever you want that's movable and install whatever you want that's in your backyard. So ultimately, the law is very vague because it lists the word items. And so it doesn't allow enforcement on any items that an HOA can't see from the front or from a side. And so it hasn't obviously put to a legal battle yet in court yet. But my impulsive thought is it really benefits property owners, specifically single family homeowners, so they can put stuff in their backyard without any fear that the association can come after them.
Yeah, so essentially they can actually use their backyard.
Well, this is interesting because on our commentary on the John Oliver video, if you recall, there was a story of the homeowners association taking drone shots of people's backyards, and they were penalizing them for things like sheds that weren't allowed in the CC&Rs, but you couldn't see them from the front, the sides, or anything. But they would literally levy fines based on their drone footage, which was crazy. So this is an interesting, again, just common sense legislation that I think is really going to improve the quality of life of just the average homeowner.
I agree.
Yeah. And to move on, there's another bill that I think is really important, especially for Floridians who live in condominiums. And that ultimately is the Senate Bill 154. Senate Bill 154, which was eventually codified, basically addresses what happened at Surfside, at the Champlain Towers,
right,
where what the Florida legislature did was it said, look, we're going to make sure this never happens again. These structural issues that should have been addressed years ago led to crumbling, and the structure just fell apart. We're not going to allow that to happen anymore. So what they started to do at the Florida legislature is they started to put in these requirements for inspections of certain condominiums that are 3 stories or higher, or that live a certain area close to the beach or a body of water. And basically, that step process required an inspection within a certain amount of time. And now what the state of Florida did is kind of take another step, kind of volume 2, if you will, of that first prong. And they said, well, look, if there's going to be inspection reports, we've got to make them available to condo owners. And so one of the things that they did, and one of the many things that this specific Senate bill does, is it now allows access to official records for any investigation or engineering structural reports. And they must be turned over to whoever asks for it within a certain time period.
Now, Jeff,
and there's logic to that.
Yeah, sorry to interrupt your flow. So what is the mechanism there for the homeowner to actually secure the report? Is it a simple email? Is it a formal demand? Is it a formal request? What does that actually look like logistically?
No, it's a great question. A lot of people think, hey, I'm going to just email my property manager. That's why I pay all these dues on a monthly basis and, respond to me. I think that, a lot of people don't get the response they want, get the response timely, or quite candidly, never get a response. And so what the statute says that if you're a homeowner in a single family home or living in a condo, you actually have the same type of right to get these records. And the way to do it in a proper way is, the way I like to say to people is you got to follow 3 basic steps. Okay, step number 1, you got to send a certified letter. I know that sounds really weird because it's to probably somebody that, is a few stories below or a block away. But unfortunately, an email just won't cut it if you're going to try to trigger the statute.
Got it.
So you got to send a certified letter, you got to mail it to a certain person, and then you got to identify the statute and talk about and specifically request what records you want. And they have to be written records that relate to the operation of your association. And if you basically follow those 3 generic steps, you're going to use the statute correctly. And it actually puts then the onus on the association to give you these records, and they got to give it to you in a very immediate time period. A statute actually says within 10 business days. And if they don't give you the records, and most people think, hey, they're just not going to give me the records. Well, if they don't within that time period, and kind of an ironic turn of events, you could actually fine your association a certain dollar amount. And then you would even have additional legal claims that you could eventually try to escalate if you really want to.
Oh, that's great. And then one final question on that. You mentioned a specific individual. How do you identify what individual you send the request to? Is it the agent for service of process? Is it a specific board member or director? Is it the management company typically? How does one identify?
Yeah, so it's the same whether you're a condo owner, a homeowner, or even you live in a cooperative in Florida. And basically the statute says that you would have to mail the statute certified USPS green card receipt, and you have to address it specifically to your association's what's called a registered agent.
Okay.
And a registered agent in Florida is basically somebody who's allowed to receive formal documentation or correspondence. And you can usually, in an easy way, find out who your registered agent is if you go on the Florida Division of Corporations website and do a search, and you can usually find that information out pretty quickly.
Wonderful. All right. Thank you, Jeff. That was great.
That's interesting.
Yeah. And, I think maybe one other bill that was interesting to me, and I think it affects maybe more so the west coast of Florida, typically House Bill 949. And it basically sets limits for age limits for who can drive a golf cart in areas. And I know a lot of people are like, well, I mean, whoever owns a golf cart is definitely doing a little bit better than me. But I will tell you that, especially on the west coast of Florida, where associations are really expansive, and there's huge communities, there's subdivisions, there's master and submaster associations, and if you have friends, driving your car, maybe might make a lot of sense. And if you're fortunate enough to have a golf cart, then a lot of people, especially with golf communities,
Right.
A lot of associations being part as golf country clubs. That's where this is really more prevalent. But I think that this is more of a health and safety issue. I mean, I think when you don't see a golf cart on a golf course, your immediate thought is, oh my gosh, there's going to be a teenager that's driving that cart.
Right.
And so. Because I think most people think that way, I think it was pretty basic and obvious thought that you got to put restrictions, and so this was one that I thought was very helpful, but like I said, probably impacts a smaller communities that are more centric to expansive associations or affiliated with golf courses.
Jeff, what was the requirement then? I think it was more or less for kids. Do they have to have a driver's license, or do they have to? I mean, what's the actual requirement?
I believe it is. You have to have a driver's license, and the driver's license age is 16 in Florida. You can't have a permit at 15. But off the top of my head, I think that there might have been an extra addition that if you don't have a license, you do need to ride with somebody. I don't know off the top of my head that exact provision. All I can tell you is, in terms of the regulation, they did hunker down on the restrictions of who can drive under what requirements.
Yeah, no, I think this is great. And again, I think it's just another pragmatic approach that Florida is taking. So I really like this one, and it is a very Florida law. It screams Florida to me when we're dealing with golf carts, because we really don't see that much in California, but I know Florida is like sort of the epicenter for golf carts.
Again, it's just common sense.
Yeah. So, yeah, I like that one.
Well, the thing to me is that it took until 2023 to address this. And, I think that most people decades. I grew up here. I was born and raised here. I grew up close to a golf course. I mean, there's golf courses all over the place. Um, People retire here to play golf. I mean, there's snowbird season here. So my guess is people from the Midwest that want to come down and evade the snow, or people from the Northeast, like New York, Connecticut, New Jersey, Pennsylvania. Those people want to come down and, wear shorts in January.
Right.
And so I think for them to address a law like this, was a long time coming.
Well, as they say, Rome wasn't built in a day. So
What was fascinating is I encountered this when I visited Georgia, and they have a master plan community in Peachtree City that literally has the main thoroughfares are golf cart centric. And even at the grocery store, there's golf cart parking. They take their kids to school in golf carts. I mean, it was fascinating. I'm like, well, this is a different way of life, getting in a car here in Southern California, and you go 4 miles and it takes you 45 minutes. Right. I kind of enjoyed it.
yeah. All right, Jeff, what do you got next for us?
Well, I think that, in terms of 2023, I mean, there's a few other regulations that were put into place, or bills that were put into place. There's a COVID restriction now preventing, organizations from putting masks or any type of protective gear there. I think that's kind of an extension from what the state of Florida did when COVID first hit. With regards to associations, they put emergency orders in so that basically associations could themselves decide, from a health and safety perspective, what is necessary for each community. But in doing so, they had to do it in compliance with experts, health experts, and from the Florida Department of Health, for example. So one of the things that I think that was just elaborating on this is, while most people are walking around freely and COVID is not as prevalent, it's still around. And so I think what the Florida legislature was doing there is also thinking about future issues. God forbid there's another epidemic or pandemic. I think there at least the infrastructure in place that the state of Florida is taking this position of, businesses can't do certain things when it comes to health and safety issues. So I think that was just another addition there.
And that was Senate Bill 252, correct?
Correct. Senate Bill 252. Agreed. So, but beyond that, there were a few things one final bill that I think is very critical to talk about. Which is a bill that was addressing construction law issues and basically a statute of repose. It was Senate Bill 360. Okay,
Jeff, what is a repose? Sorry.
Defect claims. So a repose basically means that if you find out something, you can only bring a legal claim or action within a certain amount of time. A lot of people confuse it between a statute of repose and statute of limitations. A statute of limitations usually means that you can bring a certain claim from the date you kind of know there was a breach, or that there were certain damages that occurred. With a repose, it kind of means not from when a breach or damage occurs, but basically when something even starts. So what was happening here is, let's say there's a developer who wants to build an association, okay? And it's a developer-controlled association. They're building. And you would think that the developer's business desire is to build, and sell immediately. Well, what was happening is that a lot of people weren't too happy with the way the buildings were being constructed in these communities and these associations, and they were getting sued a lot. And so now the builders and I guess their lobbyists have taken a position that we kind of want to minimize these lawsuits. We kind of want to just keep any type of construction defect lawsuit going down. So a lot of these developers have actually taken I guess from a business standpoint, a bizarre course of action, which is, if we can try to start a project and yes, take more time than we probably were wanting to do so, but do it long enough to a point where we sell the properties, and at that point, people won't have legal claims against us because the statute of repose would have been effectuated, and therefore, yeah, it took longer, and yeah, they would have wanted to sell, and move on. But from, I guess, their business position they were taking from at least their lobbying powers was that ultimately it might benefit us more to delay, and not invite these anticipated lawsuits. So that's what the Florida legislature did. I will tell you, it's very much one-sided. And I mean, whatever, if you're a developer or not developer, it doesn't help out a new homeowner by any stretch. A lot of the homeowners' rights come more against associations, but this one, they definitely sided towards a developer.
Got it.
So that's what they did.
Understood.
Yeah. So I think that ultimately 2023 was a huge stepping stone, because I think when it got to 2024 and the new bills that have been proposed this year, I think there are many significant new language and laws that are, if effectuated, if they actually pass, and they're as is, are really going to help property owners and condo owners in the state of Florida.
Yeah, that definitely seems to be the trend. Every year it almost seems like they're bolstering and empowering the homeowner further and further. And it seems like they consistently are offering pragmatic approaches to homeowner rights. But not only that, they're actually giving teeth to these empowerments.
Yeah, indeed.
So, all right, Jeff, do you want to jump into some of those for 24?
Yeah, and one of those teeth is kind of expanding what I was talking about with the enforcement on board members not doing what they're supposed to be doing, committing fraud, and what happens there. Who's allowed to even say, "Hey, board member, you did this wrong. You committed fraud. You have a conflict of interest." How do we do? What do we escalate? What do we do? And so the Florida legislature saw that that's what was happening. And what they had basically proposed is this Senate Bill 426. And I will tell you that this is a language stays intact, because what it effectively does is it creates a pilot program specifically for a condominium fraud investigative unit within the state of Florida. And the arm that they're giving this new power to is called the State of Florida Department of Professional and Business Regulation. It's the Department of Business and Professional Regulation, the DBPR. And what the DBPR has done in the past is simply monitor and regulate other types of disputes, like, for example, election disputes in an association, or if somebody is trying to recall a current board member and there's a dispute arises there, the DBPR would try to address those. And there are other legal disputes that the DBPR has addressed historically in Florida. But what this proposed language is really looking to do is it's trying to strengthen and broaden the DBPR's power, and to basically enforce them to use the statute that was just created last year and try to be the enforcement power, if you will, to get these board members who probably shouldn't be in power anymore out. And so, for example, the statute or the proposed language as written would give the power to the DBPR to enter into contracts with investigators, conduct audits. It would even give them a power to serve subpoenas. And I think that this is critical, because now all of a sudden you have this kind of quasi-court system, if you will, or quasi-judge that is allowed to work this up and get all the information they need, so that a person that feels like they know something's wrong and maybe can prove it through an official records request, they didn't have anywhere to go. And, do they file a lawsuit? Do they, file a complaint to the Better Business Bureau? What do they do? And so now this gives hope to condo owners and property owners to say, hey, look, now I can at least, have somebody who can have my back and get the DBPR to really dive in, which would be an option that they just never had. And a lot of people we would get calls from would say, should I contact the police? What do I do? And so I think that this really helps, give another opportunity to try to enforce these now stricter provisions of 2023, and now would probably take any type of overflow in a court system or legal enforcement and putting it in the hands of the state of Florida. So the hope is that the DBPR now will get the resources it needs, because now they're gonna, if the bill passes, get the power that they needed.
So Jeff, that's interesting. So is the DBPR is that a new department that is being proposed in the pilot program, or is that already established and now the pilot program is giving the power to the DBPR in order to help facilitate and enforce the these HOA claims?
Yeah, so historically, so the quick answer is no. The DBPR has never had anything like this before.
And it's established.
It was typical that the DBPR has been established for decades.
Okay.
That entity is usually overseen, like I said, election disputes, recalls, also historically overseen, any other issues that don't involve contract disputes, okay, or fraud. But now what they're doing is they are allowing this, at least this pilot program, if the bill passes, to give them this new additional right. And this pilot program would be within the DBPR that has been established. And so that they now would have the ability to oversee and hire others to investigate, putting out these subpoenas and eventually leading to conclusions. And, like I said, this is drafted initially. There might be subject to changes in the language. We saw that last year where there was a even stronger legal teeth to the fraud, board fraud law that eventually got enacted. So I am curious to see, the kind of how the proposed bill morphs, if at all, before it becomes law.
Jeff, quick question on that, more of a logistical question. How is that triggered then? How does a homeowner trigger that enforcement arm? Has that been discussed? Has that been clarified?
Yeah, so great question. So, right now, at least the thought process is, and I think that's probably there's gonna be language that basically, in my eyes, the idea that makes most sense is to just trail what is already the procedures that are already in place with the DBPR, which is you usually have to give some sort of notice of intent. And if you're an owner that doesn't necessarily want to immediately through an arbitration process or submit some sort of complaint to the DBPR, usually the general protocol is giving some sort of notice of intent to the board member or the association, and giving them, a reasonable time period to say, hey, look, if you don't agree to these demands, and I've got these very valid concerns, my hope is that we can avoid this and you just agree to this. But if not, then I'm going to be able to file a complaint with the DBPR. And if they view this as something that they're going to undertake, then, I'm going to leave it in their hands.
So it's
usually that is the
Oh, sorry to interrupt. So what you're identifying essentially is there's a somewhat of a safe harbor provision to start, but assuming they don't capitulate, the HOA refuses to adopt the position of the homeowner, then it would essentially move forward accordingly.
Yeah, at that point, if after a certain time period to kind of say, hey, look, I really don't want to escalate this, but I'm giving you this notice of intent that I'm going to, and time passes or there's no response or they just disagree, then a property owner can file what's called a petition for arbitration within the DBPR.
Got it.
So that's the standard protocol, and that's when the DBPR would decide whether they take it and assign a file number to it, or just say, hey, this isn't our bag of potato chips. We don't handle this. but we wish you the best.
Understood.
So-
Okay.
This is interesting because in that CNBC video, when they did an overview on the kind of the state of HOAs across the country, only, don't quote me, it was something like 6 or 8 states only had a department that they could go to
Right.
to file complaints. So it's interesting that Florida's adopting. They're going to be one of very few states. If this goes through, they're going to be one of very few states that can actually help facilitate these claims.
Yeah, and it sounds like in a very meaningful way. A lot of the ones that were discussed on the CNBC video said, yeah, they can investigate, but there's no enforcement arm to it.
Right.
It doesn't have teeth, right? So this one is not only creating that, but it's actually establishing it in a way that actually is meaningful,
Yeah,
right? So that's great. It's a huge improvement,
that could be
potentially.
a landmark. Yeah.
No, for sure. I wanted to talk about maybe a few other statutes, maybe kind of clump them together, or not statutes, but proposed bills, but clump them together. You know, I want to talk about one that that I actually noticed that prior to this call, I wanted to talk to you about and give you a list, but there's one that I think is really important. Actually 2 or 3 that are combined. So it's House Bill 1021, House Bill 431, and House Bill 627. And I'll through those each very briefly. Easiest one to talk about first is House Bill 627. And I'm clumping these together because I think they all give better rights property owners. And with what House Bill 627 does is at least it's proposing language that is requiring disclosure to prospective purchasers of homeowners to obtain certain documents like the condo docs, the governing documents of your association in advance. Because what we see happen a lot is people will buy a home and they might have these rights to see the governing documents. Maybe they don't have a real estate agent. And they say, well, I moved into this home and I have this dog that I've just had for years. And I love this dog, but this dog has grown up so big, so fast, but I love him to death. He's a family member, okay? What happens occasionally is there are some use restrictions in governing documents that a lot of people just, don't realize until they actually move into the community. Or I just bought this great vehicle, this huge SUV. It's oversized, but it's awesome. I have, 3 or 4 kids. It's going to be great. And I needed a bigger house because I needed to expand. And there are sometimes you'll find use restrictions in your governing documents that says you can only have certain type of vehicles in your car, in your house, or they can't be commercial vehicles or something like that. So this is an important law because it basically says, look, if you're going to buy into a home, you kind of got to get to know, make sure you got to know what you're getting into. And this gives people the right to say, okay, I'm going to get these documents. And then there's a safe harbor provision to say, oh my gosh, the closing is in 3 days. I just realized that I'm not allowed to have my dog or I'm not allowed to have my vehicle here. How do I get out of this now? So this could protect purchasers and more importantly, make people more informed when they buy a property to make sure what they're getting into this deed restricted community. Another bill, 431, this one also affects homeowners, not necessarily condo owners. And this is an interesting one because currently as the law is, a lot of people get violations for silly things. We had a client who during the holidays would put garden gnomes out in the front of their property. And they did so for years and years and years. And all of a sudden, the HOA with a new board says, hey, you're not allowed to put garden gnomes in your property. And for every garden gnome, we're going to fine you $100 a day until you remove the garden gnomes. And the law says that the association could fine you up to $1,000 per violation. $100 a day up to $1,000 unless your governing documents say otherwise. There's some cases where the governing documents say, hey, look, it says $1,000, but we'll do this in perpetuity. But ultimately, what this bill is going to be doing is limiting it, the fine cap from $1,000 to $500. And I know for a lot of people maybe out there, $500 doesn't sound like a lot, but for a lot of people, $500 is a lot.
And it adds up.
And I think is a cap, especially if it's per violation and associations are trying to target you and harass you. They can't just come at you and say, hey, you have 10 garden gnomes. I'm giving you $1,000 a fine per garden gnome. That adds up pretty quickly. And so I think that one, if that passes, is going to really help property owners, especially trying to push back on these exorbitant and excessive fines that associations really impose.
Well, yeah, it looks like they're
against them.
they're looking to sort of disarm the associations quite a bit with
They
that
are.
one. So
They
no, that's
they
great.
are. Yeah. And as one final bill that I wanted to make sure to kind of clump in this one is House Bill 1021. And House Bill 1021 is really going to be important for condo owners. I just mentioned a bill regarding HOA owners and single family homeowners, but for condo owners, House Bill 1021, if passed, is really going to be very important because it's going to do a few things that are critical. The first thing is, and if you can believe this, condo boards don't have any obligation whatsoever to sign a certification that they know what they're doing. They have no obligation to take a course and certify that they're going to fairly and equally enforce the rules. This House Bill 1021 will require that either before or 30 or 60 or 90 days after you get elected, you're going to have to take a certification course and you're going to have to sign a certified requirement that you are going to fairly and equally enforce your community's governing documents. I think it's absolutely critical. Board members kind of own up to their job and sign their name to what their responsibilities are.
This is
I
fascinating.
think another critical part of this one, another fascinating one, is a part of this same House bill is they're going to change the requirements in website content requirements. So for all the website creator people that are watching this, be very interested because currently the law is if you're in a condominium of 150 units or more, you are required by law to have a website so that people can access various information, maybe make their monthly due payment, or get more documents that are posted online like board meeting minutes, governing documents, and those types of thoughts. But now that's 150 units. There's a lot of condominiums that are less than 150 units in Florida. And for anybody that has any condominium that's 150 units or less, where do you get the documents? How do you get this information? It's not easily accessible. And so what this proposed same bill is going to do is diminish the number from 150 units requiring a website to 25 units per association. So if you have 25 units in a condo or more, which I will tell you is probably now going to be well past the majority of condominiums in Florida, associations would be obligated, statutorily required to have a website and post all the necessary information to make sure that owners are fully informed. And I think this usually will help the little guy because 150 condo units usually are big, robust condos, and smaller condos don't get that attention. Well, I think for condo owners, this Florida legislature, I think, and if the bill passes, it's going to give you more transparency that I think you've been desperately needing.
Jeff, as I see it walking away, I mean, looking at this, I love it because you're looking at Florida, and as I sort of extrapolate out, they're empowering the homeowners, they're disarming or they're making attempts to disarm HOAs, bad HOAs. There's an accountability factor. We're moving into, putting more teeth to the legislation. And, I think this is wonderful stuff for homeowners. I mean, every year, like I said, you keep empowering the homeowner more and more and more. And I really think that's a byproduct of Florida seeing really bad HOAs abusing their power over and over again.
Just the thought of making sure that people on the board have some sort of training and sign away that they know what they're getting themselves into. Imagine how many disputes will be diminished just based on education
Correct.
alone.
Well, it's accountability, but you're also educating.
Yeah,
right.
absolutely.
Because when you step on a board as a board, as a director or a board member, that is a huge responsibility.
Indeed.
That's a huge fiduciary responsibility. There's a lot of requirements, and to start holding these board members accountable, it's not just sort of club that they're a part of that they don't have to take seriously. Now Florida is saying, no, this is a serious role. We're going to hold you accountable, and we're going to arm the homeowners, to the extent that you're violating their rights.
Yeah.
So, Jeff, this has been absolutely phenomenal. Thank you. I appreciate that.
Thank you very much. And I echo everything you just said. It's just property owners have felt for the long time lack of transparency, lack of communication, lack of accountability. And I think these bills are definitely a dramatic shifting of the historically uneven balance of power and rights, and they're putting it back into the homeowners' hands. And I really think that there's only better to come as we go forward in the state of Florida.
Jeff, I couldn't have said it
Thank
better
you very
myself.
much for having me.
No, thank you, and thank you for your thought leadership and all you're doing in Florida. Thank you, and Marty, thank you as well for being on the show.
Thanks for having me. Appreciate it.
All right, thank you guys for watching, and we'll see you soon.